So, unfortunately, there's no such thing as an international patent. Now, that would be very convenient. It'd be really nice if there was a central authority where you could submit your application, and if allowed, would be protected across all the entire world, across all jurisdictions. So the way it works is that each country has their own individual patent office, and in order to secure patent protection in that jurisdiction, you have to pursue patent protection through that patent office. For example, in the US, we have the United States Patent and Trademark Office. As you can see in the background, this is the USPTO office. It's located in Alexandria, Virginia, and the US Patent Office grants and issues patents for the US. Now, most countries have their own patent offices. So if you wanted to get a foreign patent, say in China, say in Germany, UK, or France, you could file patent applications in those individual countries. So there's a couple things that I want to make very clear at the outset in this episode. One is I want everyone to understand that it's very important to understand that there's a deadline for pursuing foreign patent rights. What we often see inventors who pursue US patent applications, either provisional or non-provisional. Remember, after you file a patent application, whether it be a utility provisional or a utility non-provisional or a design patent, your application is granted a serial number, and if you satisfied all the formalities, it's also granted a filing date. Now, it's very important to remember that you have 12 months, 1 year from the date you file in the US. That's called the priority date, if that's the earliest application on file. You have 1 year to pursue foreign patent rights. Now, there are a couple of things that you need to understand. So in the most basic example, let's say that you do a lot of business in Australia, for example. And so you want to pursue patent rights in Australia. What you could do is you could file a patent in the US and then in 12 months submit a patent claiming priority to the US application in Australia through the Australian Patent Office and pursue your patent rights in Australia. Now, you could select one country. Some people will file in multiple countries, but the most important thing to remember and to always keep in mind is that at the minimum, you better file in foreign jurisdictions within that 12-month period. So that being said, there are a few tools that you want to keep in mind. So one is what's called the PCT, or the Patent Cooperation Treaty. Now, the PCT is a cool mechanism because remember how I said you have 12 months from the earliest filing date? Well, the PCT actually buys you in the simplest sense, at least 30 months to make the decision of what countries you want to pursue foreign rights in. So, as an example, you could, for example, file a provisional application. Let's just say hypothetically you file it today, July 22nd, 2020. So by July 22nd, 2021, you had better file your US non-provisional application if you want to maintain the priority date. And if you want to pursue foreign patent rights, then you also have to file in those foreign jurisdictions. Now, I mentioned this thing called the PCT, Patent Cooperation Treaty. It is possible to file what's called a PCT application. So you would file it, the US would be called the receiving office, and you would file a PCT application through the US Patent Office. And that would essentially give you an additional 18 months beyond your 12 months. So you would have another 18 months that you could then use that time to decide which countries are worth pursuing. Now, the, in the alternative, you could just outright file a PCT application. And again, you would then have time to make the decision as to which foreign jurisdictions you want to file your patent application into. There's also what's called the European Patent Office, and it's under the European Patent Convention, but the EPO, European Patent Office, allows you to file a patent application at the EPO office and then If the EPO grants your patent, then you can what's called validate it in individual countries in the European Union. The EPO and the PCT are good tools that you want to have in your arsenal. Now, one thing I have to caution you against, um, for filing foreign patents gets very, very expensive. So, as an example, if you file in a foreign jurisdiction like Germany, keep in mind that you're going to have to pay what are called annuities even while your patent application is pending. So these are fees that you have to pay to the foreign patent office even while you're waiting for your patent application to be granted. We don't have that in the US. In the US, we have what are called maintenance fees. So while your patent application is pending in the US patent office, you do not have to pay annuities. However, after your patent is granted, you have to pay annuities, or we call them maintenance fees, at the 3.5 year mark, 7.5 year mark, and 11.5 year mark after issuance. So keep in mind that not only do you have to keep track of the annuities, because that's the real cost, I think. The annuities themselves aren't all that much, but tracking the annuities and making sure that they're paid on time, that is a hassle. And in the more countries that you're in, the more countries that you have to be sure you pay the annuity fees in. Now, another thing that I want to point out about foreign filing is that while your application is in those foreign offices, you're going to have to hire a foreign counsel to handle the correspondence and to handle the back and forth with that foreign patent office. So, for example, if you were to hire, say, one of us at our firm at a DBIP group, yes, we could handle the prosecution for your U.S. patent application, but once you tell us, oh, and by the way, before my 12-month priority date is up, I want to also file into China, we could do that for you, but we would have to involve foreign counsel. So Chinese counsel we would hire them. They would prepare translations of your patent application and handle all what are called the national fees, basically the government fees. And then on top of all those fees, you also have to pay their bill. So just keep in mind, it can get fairly pricey. What Depending on your size, you may want to focus on pursuing US patent rights. Now, what are some good countries that you may want to consider depending on your size? You want to probably hit the largest market share. So generally, what we tell our clients is that if they can handle the UK, if they can pursue patent protection in the UK, Germany, and France, then that will afford them a large part of the European population. And then it's just a matter of whether or not you want to consider Asia. So several of our clients will pursue patent rights in the UK, Germany, and France, and then also in China and possibly Japan and Korea. So it all depends on how aggressive you want to be with your foreign filing and how much resources you have. Now, the one big thing that we have to keep in mind, even when we're filing into the US, is how much are you willing to spend to protect and defend your patent? So ultimately, and this is one of the most important things to understand about our patent system and patent systems worldwide. An issued patent is only worth as much as you are willing to spend to defend it. So if you're going to file in foreign jurisdictions, but know with conviction that you're never going to spend a dollar to try to enforce it, then you really have to ask yourself, why are you doing this? Now, there might be reasons. For example, certain investors might care about that, but it's important to really understand what you're paying for. And if you don't have the resources or don't want to ever invest the resources in protecting patent rights in that foreign jurisdiction, then it's probably not a good use of resources.